Okay, so, without further ado, thank you again for those of you joining me during your lunch hour to talk about elections. I did it on my slideshow today that is based on baseball, which saddens me because if you don't know already, the first week of spring training has been canceled due to a disagreement with the players. And I hope that it will be resolved fast so everyone can enjoy some baseball and some spring training. And I also hope the weather changes too, or we can enjoy baseball and nice weather. For those of you who don't know me, I'm Christina Morgan. I'm a partner at VF. It will be November 1st of 2022 will be trying to think how long I've been here. My goodness. 8 years. Be 8 years for me at Vile. I like general counsel. I do a lot of enforcement work, dabble in a little bit of insurance defense with what we have. It's not my favorite. Do a little bit of collections because that's the nature of the beast. But for the most part, I help a lot of communities with general counsel issues, amending their docs, and including election oversight. These questions have been coming up a lot. Those of you who weren't on earlier that heard me, I think people are generally paying more attention now as meetings have been virtual and it's somewhat easy just to log in, right? And keep a board meeting on Zoom and have your camera off and listen to what's going on. And I think generally people have been more willing to volunteer when they don't physically have to go to a meeting. And so these positions are hard fought for. And then also after the election, there has been for, I don't know how to describe it, maybe a lot more seriousness when it comes to running a fair election. So a lot of questions come up from managers, from board members about policies and what should we do. If you have a question, please let's put it in the chat. And that way we can share with the group. I want you to ask questions. This is elections are and how you hold them. There is some statute that applies, and of course we'll talk about it. But for the most part, I mean, whether your ballot is held secret, when you're going to hold your meeting, very document driven, and there's a lot of choices and more ways than one to skin a cat. I don't believe the law has caught up with HOAs holding virtual meetings. And so we get a lot of questions about notice and where to hold a meeting. And so let's go through it. Rob, have you joined us yet?
I'm here. Sorry about that.
Oh, no, sorry. So I'll let you introduce yourself. Rob's the better looking one of the group.
I don't know about that, but my name is Rob Berry. I've been representing homeowners associations for 20 years now. I typically do litigation. I've had a jury give me $1 million. I've had a defense verdict in favor of the association. So I've done a lot with that. The other thing that kind of frequently is kind of tied to litigation or many times is insurance and insurance coverage. I deal with insurance issues, coverage, claims that the association has, claims against the association, all that kind of stuff. Thanks.
For those that you don't know, Rob and I often litigate together, and Rob is the good cop and I'm the bad cop. I'm the one who kind of escalates and is mean, and Rob is the nice guy who negotiates things. It works really well. We have had to litigate some election issues, believe it or not, in the past. And Rob likes to talk about his jury verdicts and how much he's been awarded. But my favorite case with Rob was one we had years ago with Jonathan DeSalis. For those that you may or may not know him, he is a lawyer that is often against HOAs and represents homeowners. But we had an election And the question before the court was disclosure and whether or not the board or the association needed to disclose election materials. This was before the statute changed and election materials could be inspected by the members. It wasn't clear at that time. It was actually in legislative session when we were litigating that case. I don't know why plaintiff's counsel didn't bring it up, opposing counsel didn't bring it up, but we argued that it was secret, that the election was secret, and therefore the association had a good reason when it didn't disclose the election materials. We eventually convinced them to do so. But the judge really bought the argument and thought we were sincere, which we were sincere about why we withheld disclosure of ballots. And although the plaintiffs won, the court only awarded them their $300 filing fee. And yeah, I thought that was it was the best result, because once the statute passed, then there was a clear directive from the statute from telling associations you had to disclose records. But that was what the law hadn't changed. And Rob and I argued it. And the plaintiff's counsel was very unhappy because he lost $22,000. So it was a fun one. So that was an election one that we have litigated. I'm hoping today that we go through our PowerPoint. We will give you tips for avoiding and ending up in our office. I don't want you to be with us for election problems. I would rather you talk to your counsel, if it's not us, about what you should or shouldn't be doing when it comes to running elections, so you don't have to spend a lot of money or really get to know your attorneys that well. There are other ways to spend association money on attorney's fees. So let's start. So annual elections, annual once a year. Some documents will require that a certain day. We have an association that says every second Tuesday of February, there must be a annual election. Some say just annual election. Some are silent. But there needs to be an annual election, obviously once a year in the state of Arizona. That's what the statute says. Admitting people. Terry, will you admit people as they come in so Rob and I don't have to worry about that, please?
Yeah, some governing documents require the election be on a certain date or a certain week of a certain month or something like that. But other than that, if they run a little over, that's pretty typical.
And that was happening. So we got a lot of questions about, hey, Christina, we put off our annual election because of the pandemic. I'm worried. Are we going to get sued because we didn't hold an annual election? And so my answer to them was, well, has anybody complained about it yet? I mean, yes, you need an annual election and you need to hold it. But what would happen if you got sued on not having an annual election? The remedy would be you hold an election. So I was just telling people, if it's a concern or you need a new blood, you need to get to do the annual election, whether it's got to be virtual. I think everyone has kind of returned somewhat to the normal schedule since the pandemic is letting up now to holding their annual election. There was a question about holding your annual election, and it came up in a community where the annual election was delayed to the pandemic about terms and when your term would be up. And it was not clear in the documents about if a director's term was up at the annual meeting, or was it up after holding a certain 2 or 3 years, give or take a few months because of delay of the pandemic. So we did see a fight this year about what it meant for a full term. Did the term mean to the next annual election, or did it mean a full 3 years on the board? And that comes up in the removal context. I don't know if you want to even touch on that, Rob. Rob's been gracious enough to
Yeah, I think we'll cover it during the removal.
Okay, that's fine with me. Oops, this is a course syllabus that I'm cheating on, so you can see my notes here. I just want to make sure. So annual election, that's governed by ARS 33-1804. If you're a planned community, that's B 33-1804B. And if you're condo, 33-1248B. So your location, in person, virtual, or hybrid. And then, of course, your notice for annual elections, not less than 10, not more than 50 days for your annual election. We did have it come up in one of our associations about, do you need to put the Zoom login information on the notice? And there was an argument that you should, because that's but location, if you were holding it by Zoom, not making it hard for homeowners and say, hey, I want to go, and then have to contact the manager for login information. There are balancing concerns with security and providing that information to non-members or people who shouldn't be in the meeting. I don't know what sadistic person wants to break into an HOA meeting, but I'm sure it happens. The law hasn't caught up with virtual meetings, so just understand that. I would play it safe and send out your login information by Zoom on your notice, just to make that clear. I'm not advocating hiding your Zoom information. Okay, let's talk about candidates for the board. So some associations will have nominating committees. Most don't. Most is just hard. Most associations, it's just hard to find volunteers to get on the board. So we do a call for candidates. And of course, your people are interested, your members are interested, will send in their bios, right, to distribute. So over the years, we've had fights about they missed the deadline. They were a day late. Should I hold back from sending out their bio because they were a day late? I don't think that is a great excuse if you haven't already done the mailing. If you've already done the mailing for the bios, then oh no, I think that ship had sailed. What's reasonable in that situation? And of course, there are always questions about, well, so-and-so is in litigation with the board. Can they even run? Well, do your documents disqualify someone who's in litigation? Or most documents will say that people cannot vote if they are delinquent or in violation of the documents, but many of them do not. Many documents are silent as to disqualifying someone as a candidate for the board. So that might be something you might have your association's attorney to look into, because obviously someone who isn't following the documents is probably not a great candidate for being part of the board. Let me back up here. Someone had a question. As far as annual meetings, do you have to abide by the document if it says second Tuesday of December, or since a regular board meeting is in November, you just move the annual meeting forward to be held at the same meeting? That's one of those things where you make a judgment call, like what's reasonable. Obviously, the documents tell you to do something and you violate it. Yeah, it's going to be a procedural violation. What's the remedy? You hold a meeting as soon as possible, right? So if you can get a consensus that it makes sense to move the date, then sure, do that. But also think about maybe amending your documents to take out that restriction about a certain date. And that way you have more flexibility. Okay, so let me go back to candidates to the board. So not only do you have these issues of, is somebody qualified to run for the board? And that's going to be in your bylaws, whether someone meets the qualifications for the boards. The basic qualification to be a board member is usually they own property within the association. This gets hairy sometimes because we've had issues. Well, what's the definition of an owner? Some documents include people under purchase contract. They will be included and therefore could be a candidate of the board. It also gets a little bit hairy when you have a corporation that owns the property or a trust. I've had it come up in associations where the beneficiary or trustee may run for the board, but we couldn't prove or know without getting further documentation that someone truly was a beneficiary of the trust. And the notice, let's see, where are we at? Oh, so the election policies, I think, Rob, you've written a couple of these. You got to be really thoughtful on the timeline of obviously calling for candidates, getting their bios back in time to prepare a mailing with the proper notice to go out, not more than 50 and not less than 10 days than the annual meeting. And so, yeah, Rob, I think you've written a few of these policies on these timelines.
Yeah, they just, I mean, basically you have to match the documents. They can't be inconsistent with the CCNRs or bylaws.
Sometimes they're just not, it's silence, and we just go ahead and we write a policy based on historical practice. So
Oh, hey, you have an interesting take on nominating committees. Some CCNRs or somewhere in governing documents, they call for this big nominating committee stuff. And why don't you tell a little bit about your take on the nominating committees and nominating committee meetings and those processes?
I don't really like nominating committees.
You say they disenfranchise,
Well,
or they can.
they can. I mean, let's be honest, elections are a popularity contest. And a lot of times nominating committees will say, well, I'm a nominating committee, and therefore I have the right to say such and such shouldn't be nominated as a candidate for the board. But if they meet the basic qualifications of the bylaws, is it really reasonable to not put somebody on the ballot? I'd rather put them on the ballot as your attorney and tell everybody not to vote for them and they lose than to just say they can't be part of the ballot at all. I don't know. Do you
Yeah, no,
agree?
I agree rather than getting sued over it.
Well, yeah. I mean, if I'm a really bad lawyer, I tell you just to not let people run for the board so you can end up in my office and I can bill more fees for having to run your election. We have come across where elections have not been run very well, and part of the settlement is that there's always third party oversight. We'll talk about that later. Someone said, you said a beneficiary for a trust may run what position for a corporation or LLC? Uh, Member, somebody who's a member of the corporation, the LLC. That's normally the standard. All right, so let's go. Oh, so just so you know, there's some ridiculous pictures about baseball in here. Like this was considered one of the most, this is an actual baseball card. I don't know. He looks very in love with that bat, but this is an actual baseball card, I think from the 80s. Election policies. So, like I said, Rob said, you know, hey, we draft these election policies based on governing documents. We do it on historical. We also, of course, go by the statutes and what you need to put on them, put on the ballots, I should say. So we like election policies. They help to cut down on fights about when resumes should be submitted, when things are going to be sent out. They give quite a very good direction. Let me see. I don't think you absolutely have to have them. So don't go freak out and say, I got to go to my attorney and go get an election policy. Yeah. This is not rocket science, and this is not a presidential election. Yes, it needs to be taken with seriously and done right. However, I don't think that if you don't have an election policy, I wouldn't go be totally upset about it. We need to do what's working and what, of course, is legal. So there's your nominating committees. We already talked about that. Oh, and I don't like nominations from the floor because the absentee ballot has to have a candidate on there, right? And people vote by an absentee ballot. So if you took a nomination from the floor, you essentially disenfranchise anybody that used a absentee ballot to vote, meaning in layman's term, I'll try to stop speaking like a lawyer here. If you nominate somebody by the floor and I send my mail-in ballot in, then I don't have a chance to vote for whoever's nominated from the floor. And so lawyers differ a little bit in the opinion in the industry on this, but most will tell you, HOA, ones that focus on HOA, to not do not take nominations from the floor and get that language out of your documents if you've got it. And that has to do with the way the statute is written. I see people typing, and I wonder if there are questions coming in about this. Oh, wait. Ooh, there's some. Do candidates have the right? This is Ramiro from Scottsdale Shadows. I'll call you out, Ramiro. Thanks for joining us. Do candidates have the right to obtain contact information of the owners? If current board members are running for re-election and they have access to that contact information, it makes hard to say no to those candidates making the request. I agree with you, Ramiro. So we normally will split the baby here, and we'll say homeowners, of course, if they do a records request, they would have a right to the member list and the address information. But we drew the line at telephone numbers and emails as personal information we don't want to release. However, it's not fair to withhold that information if a current board member is using that information for campaigning. Why isn't it available to the other candidates? And that's where it makes it inherently unfair, and I think it could be a fight. I don't know where I think a judge would be reasonable and said if you let one candidate, whether they're a current board member or not, you're going to have to let another candidate use that information. In places like Scottsdale Shadows, where Ramiro is the general manager, everyone's pretty close knit, and they are condos. So I can imagine it's probably pretty easy for people to print some flyer out and go door to door and put it on their door. It's probably not as easy, obviously, in planned communities or places that aren't quite as compact. Another question. Great questions today, guys. Can an existing board take a public stance on whether or not they approve of any particular candidate, or conversely, do not wish to see them win? All right, my rule of spandex, for those of you know me, just because you can wear spandex doesn't mean it's necessarily a good thing. Some days it looks great, other days it doesn't work out well, and you probably shouldn't be doing it. It is, there's nothing that says you can't say, hey, I don't like Bob over there. I think it'd be terrible on the board. He's nothing but a gossip, and he just wants to be on the board because he wants to put in these oleanders that the board hates. You certainly can say those things. Remember, you might open yourself up to defamation if those things aren't true. Even if they're true and not nice, elections are very divisive. We already know that by our country and the state of affairs here. And so I'd ask yourself, how you deliver that message. Maybe the message should be, I really like Linda. She's way better candidate. She is fair to everyone, and she just wants to be on the board because she needs something to do. That might be a little bit better message received than Bob sucks because he wants his oleanders in, right? Oh, I like these questions. They make this a lot better. And it's really hard, guys, to do these seminars virtually, because we don't know if you're laughing or you're bored to death and crying or sleeping. So thank you so much for asking questions, because at least I know certain people are engaged here. All right, let's talk about board vacancies and appointments. This is very document driven. Somebody quits. Unfortunately, people die and there are board vacancies, and a lot of questions come up. Can we appoint? Well, do your documents allow you to? Well, maybe we can appoint, but maybe we don't want to. The election's close, or maybe it's so controversial that we would rather just have an election, and that's going to depend on what a special election for filling that vacancy. It's just going to depend on what your documents say. And also staggered terms too. We have to watch for staggered terms, and if you don't get quorum and when you fill those things, and sometimes that becomes a bit of a mess. I really like the associations that have clear documents where, it's a five-man board, and you have, 2-year terms for everyone. And so either 3 or 2 are going out every year.
Are there documents that prohibit a board appointing to the remainder of an unfilled seat? I thought a board could always do that.
There are some that don't like it. It's rare, though. Most of them do say you appoint.
And you generally appoint to the remainder of the person's term that vacated the seat.
The devil's in the details. Some documents will say you can appoint to the remainder, and others will say up until the next election. So it devils in the details. You have to read about filling vacancies in your bylaws and how that's done for your association. I personally like when a director has to go up in front of the membership after they've been appointed to get to basically sign off that, hey, they're incumbent, but they really weren't elected by the people. And I think it gives legitimacy to that candidate or who's, on the board already. It's kind of like, when you have a governor and you just appoint somebody decides to leave and you appoint somebody and everyone says, well, do we really want them? Well, they've been here doing a good job. Maybe we do. It seems to legitimize it when you have the members sign off on it and actually elect them. Okay, so someone's on this call about from Oregon, so that's nice. They run elections by mail-in ballot only as opposed to in-person election ballots. Is that what most communities do? So I don't know what the law is in Oregon. You'll have to forgive me, Carol. I go up there once a year. I wish some of the Oregon attorneys were on this call. In Arizona, we have to offer absentee ballots in elections, and we mail ballots, but we have the option under the statute in Arizona to allow other forms of delivery. I have had associations where there has been gerrymandering and they have said mail-in ballot. Oh, and also in Arizona, let me back up. You have to provide it in person. But during the pandemic, Carol, like many associations, in person was considered extremely dangerous, and many did go to mail-in only. I haven't had an association ask me to do mail-in only lately, and they're usually, even in the pandemic, some were kind of concerned about the Arizona statute providing for in-person. So they'd have somebody out in the middle of a field with a little box where you could run and put your ballot in and then run away so you couldn't get COVID. And I had to actually, I laugh, but I got paid to sit at a Ramada in 110-degree heat in August for that to happen, where people could sit and I just watched them put their absentee ballot in for a very large community. All right. I think we talked about board vacancies. Member voting. This is fun. So, of course, we're talking about definitions of a member, right? Do they own property? Your definition might include people under purchase contracts. And of course, you got to verify that they own property. Go to the assessor's website. Sometimes the assessor's isn't up to date. For community like communities management companies should have a running list of new purchases and who's eligible to vote. Understand that a member can have a representative attend and speak, but a member cannot allow their representative to vote on their behalf. That's called a proxy, and proxies are illegal. So if you really want to look at the statute about where proxies have been made illegal, if you're in a planned community, that's 33-18-12A. And if you're in a condo, it's 33-1250C. Oh, we're getting lots of questions here. I like it. Let's see. Here's somebody says, we do elections mostly electronically and only provide paper ballots to those people that don't have email or request one. Is that a problem? Well, I don't think the statute has caught up to the times. The statute, the conservative advice to give you is that the Arizona statute says that you have to provide an absentee ballot. And what does that mean? I think there's some interpretations that say you should be mailing that ballot and that requiring a homeowner to reach out to management or a manager or a director to request one may be a problem because you might disenfranchise people. I certainly have given that advice to be conservative. Go ahead and mail it to the address on file. And then, so do both. I understand there's a certain cost saving, especially the larger communities, but honestly, the postage in most communities is not worth taking the risk that you aren't following the statute. Those are the same questions about limiting mail-in ballots to people who request them. Let's talk about electronic voting. We've used a couple different platforms in several communities for online voting. One's text to vote, where every member is given a special password and they text it and they get a link to vote. Those are somewhat hard. We have to set up processes to verify that the password is specific to the individual homeowner, so we can verify that it is that homeowner who is voting. With email voting, accepting a ballot by email, that's somewhat easy as long as there's a signature line, it can be accepted. I do like electronic voting. It seems to help get quorum a lot faster, a lot better. Like you have more participation with electronic voting. And there are some that there's a link, they can do it online. Like I said, there's a texting platform. I do like online voting. And I really think it appeals to younger communities. And I'm not trying to be an ageist. I'm sorry. I'm not trying to offend anybody here. Some people just culturally, they just don't like using electronic votings, but for the most part, in larger communities, in newer communities, it seems to be some very successful, if we're attaining quorum, especially. There's another one. Is board appointment to fill a vacancy, to fill the remainder of departing members' terms strictly at the board's discretion? It's going to be whatever your documents say, what you're allowed to do. And understand too, and Rob, maybe you should touch on this with removal. Directors that are voted in by the members have to if they're going to be recalled, they better be done by the removal process under the statute. But that's different from a director who's appointed. A director who's appointed can be booted by the board. You don't really often talk about that, but that's not the same as removal of an elected director. Oh, someone says by offering both electronic and paper ballots, we have folks who voted twice. That is another problem. And thank you for bringing that up, David. That is a problem because if you submit, and that's where sometimes election policies are great, because you can't just be throwing out one ballot and keeping the other. Some documents, a lot of documents are explicit that if you vote more than once, then it's completely invalidates your entire vote. You have to be careful on that. Another, in the scenario where an owner owns multiple properties but only returns ballots for one, can it be assumed they would vote for the same at all parcels? I would not make that assumption. I would be straight if they need to get a vote. They need to get a ballot for each of their properties. Or call them. You can call them and say, hey, we only got one for this one piece of property, or we only received one and we need 5 or 3. If you can. I don't like it. I like to be strict with it in the sense that, come on, people, help me out. Let me these are the rules. So another question from Carol. She says that we have 2 alternate board members elected each year who sit on the board but don't vote. They step into a vacated board position. I've seen this in several documents in Oregon, and I'm intrigued. I like that because you always have somebody ready up to bat, so to speak. If the board member resigns and becomes a voting, then the alternate becomes a board member, and it seems to work so far. I like that, Carol. I wonder if that would work for Arizona. Maybe we should start writing that into our bylaws. Thank you for that suggestion. I have just seen that lately as I started to review. I'm doing a project for our Oregon attorneys up there. And I just saw that. And there's Scottsdale Shadows. Larry, I know you're on the call. The president of RCI at Scottsdale Shadows is on today. And they have, I think they have alternates for their board, which I think is fantastic. I think that's a really great solution. Just line up people instead of begging people to fill positions you already have. Oh, RHOA does not have a secret ballot. Do members have a right to review the electronic ballot? Yes, they do. And even if you have a secret ballot, the members have a right to review those secret ballots, even though those should be separated from the envelope. And we tried to argue in the case that I was talking about where the law changed about disclosure of ballots and records. It was a secret election. We used secret ballots, and the statute just destroyed uh, withholding disclosure, withholding ballots from a secret election, unfortunately. So yes, the statute does require the HOA to disclose that, assuming that your member requests. And I argued to the court, and I think that the judge agreed with me, that whether or not somebody votes is as important as the identity if they vote. Because what happens if someone sees that you voted, right? They're going to go and pressure you and say, you should vote, and not voting at all is also a statement, right? So we had to do a lot of research on the case law, and it was fascinating to me. As fascinating can be to a lawyer who, by standards is already strange being a lawyer. It was fascinating to me about the privacy arguments around protecting the right to vote and disclosing who votes. Arizona said, I don't care as far as HOAs are concerned, so it is not protected. In a regular election, you have to request an absentee ballot. Why would that not be the same for HOA? Well, Bill, I think that because the statute says we have to use absentee ballots, it's a legislature issue. I don't disagree with you. I think it would be a lot easier if people said, I want my absentee ballot, and it would be cost effective to the association, but that's not how the statute reads, unfortunately. I don't know why the HOA rules are different. You have any insight into that, Rob?
Other than that, the legislature treats HOAs differently, and they it's driven politically. That's about it.
So here's a question: what if the owner writes all their property's address, lot number, in one ballot? I think that's fine. We do have, so in the HOA that we manage their election that has mixed use, we actually put, you have 52 votes on their special ballot for the commercial ones, because we don't want to hand them 50 ballots. So they know that it's coming, and we make it clear that this is for all their 52 votes or whatever it is. There's different ballots, different number of votes depending on the commercial property. So I'm okay with that, Ruby. I thank you for that comment. Okay. If an owner turns in their ballot but neglects to circle yes or no, can we contact to get their decision? I think you can. I don't like it. Somebody asked if you're playing with it. Just be transparent about what's going on there. At the very worst, you don't do anything, or at the least, you don't do anything, and you just count it towards quorum. A lot of people will.
Or if they're at the meeting, you can allow them to vote in person.
Yeah. Don't start throwing stuff out, though. That scares me when people start I'm just going to throw this out, though. Please don't do that.
Well, but also that vote counts toward quorum,
right,
but it doesn't count as a vote for any of the people running.
Rob, yeah, no, I think that's, at the very least, like I said, it's a quorum, counted for quorum.
And sometimes people turn in their ballots because they're like, well, I don't know any of the candidates, or I don't like any of the candidates, but I want the association to have quorum, and I don't want them to go through this again. So they just turn in the ballot without a vote on it.
You know what is this at the bottom of my screen where it says if a director resigns, they can change their mind and resend their resignation? I don't know how that got on there. I will say that if a director resigns, I usually don't like to let them resend their resignation, especially if your documents say that a resignation is effective upon receipt by the secretary, and that happened. I don't think that you can resend it. Rescind, as rescind, RESCIND, not resend, but rescind. I don't know where this.
I think it was a question that came
on the screen.
Yeah.
I don't know how it came through, but yeah. So I'm going to say probably not. Most likely not. Oh, is there somebody to admit there? Okay. Rob, why am I back to the nominating committee?
You ready for removal? I'll start while you find the slide.
There it is.
Removal is all statute. It's very unlikely that your documents, regardless of what they say, have anything to do with removal. A lot of governing documents do have removal provisions in them, but they were written before there was an Arizona statute. So documents from the 80s and stuff may have removal provisions, but they're not going to be valid because we now have a statute that trumps your governing documents. Removal depends on what kind of a community you're in. So the statute outlines two different processes for two different size communities, or at least two different requirements. In an association with 1,000 or fewer members, there must be 25% that vote, or at least 100 votes, whichever is less, in order to initiate a removal. So that's to start the removal process and to have a meeting. And the ballots that are used, or the petition, must meet certain requirements. It can't just say nothing, or, if the language isn't right or doesn't include the members' names or something like that, the petition may be deficient. But for 1,000 or fewer members, it's 25%, or at least 100 votes, whichever is less. In an association with more than 1,000 members, the petition must be at least 10%, or at least 1,000 votes, whichever is less. So depending on the size of your community is how many people need to be in the petition. Now, the board can enforce that you must have eligibility to vote. So your governing documents may say you can't be in arrears on assessments, or be prohibited from voting because of violations or something like that. So those provisions can be enforced, but it's all basically all statutory, and it's the two different community size. Once that petition is delivered, or I usually use the word served on the board. I think the statute says delivered. Once that petition is delivered, then if it's valid and if it meets the requirement of the statute, then the board has to have a meeting on the removal for those directors in question.
We have had a fight on the meaning of delivered, by the way. Does that delivered is very generic? Does it mean at a board meeting? Does it mean sent to the president? And it's important because of the date. So I think the guidance we've given is it's delivered when your board knows that it's an issue, right? When it's given to your board member.
Yeah, I think one thing that came up once was they kind of like threw it at one of the board members, and it didn't have enough valid signatures at that point. And then later it was delivered with enough valid signatures. So I think that's one issue that came up one time. So yeah, that can be a lot of these words in this very long and several part statute can be contested and can be litigated. But once it is delivered, if it's valid and meets the requirements of the statute, has enough signatures, or in effect votes, then the association is required to have a meeting. And the meeting, the statute lays out the quorum for the meeting, which is at least 25% of the votes of the association. And if quorum is met, then the member may be removed or not removed, depending on the vote. But there is the vote at the meeting. So other members could vote against, but the statute also outlines the quorum. And if a lawsuit's filed, or if this is litigated, the prevailing party is awarded the attorney's fees. So there is an attorney's fees provision in the statute. The removal meeting, sorry, I forgot to mention this, must be held within 30 days of the receipt of a valid petition.
And that's the other reason the whole deliver date is important, as well as does it have the requisite number of members signed to even certify it? Oh, everyone who's is getting credit for CMCA continuing education, your special word is Diamondbacks. Special word, Diamondbacks.
The statute also requires that the association has to retain all documents for 1 year after the date of the special meeting. So that's a document retention requirement. You can dispose of them and an association may want to dispose of them after that, so that you don't have the ballots on hand, because if you do, then you have to deliver them to an owner that asks. And the other thing that comes up quite a bit is you can only submit one removal petition per term per director. So sometimes it comes up where there's a failed attempt to remove an entire board, and then someone really doesn't like one of the people, so they try again for that person, and they get the requisite votes the second time. Well, you can only do it once per term per director.
There's a question, Rob. If a person turns in a ballot who is ineligible to vote, does their ballot count towards quorum? Most of the documents will say votes of those eligible, and in that case, it actually reduces the number available for quorum. You would be, for instance, the one we do, Rob,
so if your quorum is 100 and only 50 of those are eligible to vote, then your quorum then becomes 50. So that's the denominator of the whether you have quorum. So the percentage that is required is lower. Does that make sense? Did I explain that?
yes, yes, thank you.
So the answer to that question is, well, no, that person's vote doesn't count toward the number for quorum because they're ineligible, and it doesn't count toward the count toward quorum. So hopefully that's clear. So your quorum number is reduced when people are ineligible. So you don't have to get the percentage of the higher number of the total. You have to get the percentage of the eligible to vote. Let's see. I think there's one other thing I wanted to mention. If a director is removed, they can't serve again until their term expires. So if you have staggered terms and someone's removed the first week into a 4-year term, let's say, well, in 2 years or 1 year, when other seats come available, they can't run until their term is expired. I don't think many have 4-year terms. I kind of use that as an exaggerated amount, but they can't serve until the end of their removal. The end of their removed term ends. So that's it. Are there questions on removal?
We have seen a lot of communities go through multiple removal elections. They go like cycle because of factions. And I'd be interested to see how you to get out of that cycle. There has to be peace offerings. We see removals a lot of times. They're usually related to expenditures and different value systems on how a board spends money. That seems to be the hot item of what puts people in for recall elections. I don't know, Rob, can you think of other ones where we see context of removal elections?
Yeah, the other thing that comes up is when what you do when the member's removed. If it's a majority of the board, the statute requires you to hold another election, or obviously the whole board. You'd have to just notice an annual meeting and then elect board members. But if it's one board member, if your documents allow, you can appoint
someone who wasn't removed.
Someone who wasn't removed. Yes.
Right. We're good on time. Oh, look at this Cal Ripken on that phone here. So we've talked a little bit about third-party oversight. Sometimes it's great especially when it's controversial. Even management companies who work at the direction of the board, sometimes homeowners will accuse them of being biased towards the incumbent board. I don't think that that's that's not that's very unusual. That's not usually true. Attorneys have ethical obligations where, well, we obviously are not supposed to lie, cheat, and steal, otherwise we lose our licenses. So a lot of boards will entrust us to certify their elections. I'm kind of the mind, well, new regime could come in, and no matter if I do great work, they have their people, they have their lawyer, and I could get fired. And so, I take it with a grain of salt, as far as I usually have any dog in any fight. I might know people, but I work for the corporation. I don't work for individual homeowners. I understand that, but third party oversight can definitely be a good thing when people are mistrustful, and just to make sure we hit deadlines and notices are correct and we get as much participation as possible.
There's a lot of associations in the Valley that are under court order to have a third party administer their elections. And there's a lot of very complicated with cumulative voting and, some mixed use communities where there's commercial as well as residential, and the commercial has, X number of votes and, stuff like that. And the complicated quorums. So, if you guys, sometimes it makes more sense to have a third party administer your elections, and it's something that we do, a service that we do offer. I believe there's other services that do that, but sometimes it's better, more professional, sometimes even cheaper and more convenient, and looks better and sends an assurance to the members that it's being handled that way, and everything just looks perfectly and is beyond reproach and not able to be questioned, litigated, challenged, that sort of thing.
Condo associations, we see a lot of hiccups with. There'll be questions about weighted votes and the percentage, and whether those charts are done correctly. People have a vote weighted based on their percentage interest of the common elements. That gets little sticky widgets there. Disqualifications. There isn't anything like pregnant chads, but there are definitely ballots that are questionable about how they are filled out. And so sometimes it's better to have independence, whether, of course, your management company or another third party, or, elections to HOA elections type company, to make that call, rather than it be a community member or someone closer to the vest. Some documents will obviously allow non candidates members to oversee and count ballots, and that's perfectly acceptable. We've done it side by side with these volunteers. In fact, I do like it that way. Normally in some communities, I will pick, when I know that there's factions, I'll pick counters that are from both sides to come watch. So anyway, we have 4 minutes. We're kind of on the dot. You guys gave us some great questions. If you're burning and you think of something later about elections, please email us, let Terry know. And we're happy to answer that questions. Again, if you're receiving credit, the magical word is Diamondbacks. We appreciate your time today during your lunch hour, and we hope that you'll come join us some other day.
Yeah, thank you for the great attendance. And we do these basically about once a month. So please take a look at our schedule, and I'm sure Terry will be emailing you, and we hope to see you again.